and welcome, dear students. Our today's topic is theories of divorce. First, its objectives. To understand the concept of divorce, to discuss the need for grant of right to divorce, to explore various theories of divorce. Now, the introduction. A marriage is an institution which provides for the exclusive union of male and female for the purposes of legalizing sexual intercourse as well as procreation and legitimization of their children. During the initial stage, the institution of marriage was considered to be of indissoluble and sacramental nature. But with the passage of time, need was felt to introduce a way to terminate marital relationship when due to one or other reason it becomes almost impossible for the spouses to continue their marriage. It happens to be resulted into the formulation of institution of divorce, which is said to be based upon various theories known as theories of divorce, under which a marriage can be dissolved upon various grounds. The term divorce stems from the Latin term divortum, which means to turn aside or separate. It's a method of dissolution of marriage which puts an end to matrimonial bonding between spouses and cancels their legal rights and duties of spouses towards each other. It is different from the process of annulment under which the marriage is declared null and void. Thus, divorce can be obtained only in the case of valid marriage. During the early period of Roman regime, both marriage and divorce were considered private acts of parties and they were free to enter into marriage or asunder it according to their wishes. Divorce in England was statutorily recognized during 1857 on the ground of adultery. Later on, the grounds of cruelty, desertion and insanity were added. Among Hindus, divorce was recognized before the enactment of Hindu Marriage Act 1955 only in the form of customs. Thus, the Act inculcates the different theories of divorce and provides various grounds for the grant of divorce. Divorce is also recognized under Muslim law but as last option. There are various theories of divorce such as fault theory, consent theory, breakdown theory, will theory, frustration theory and irretrievable breakdown theory, which are exclusive within their ambit and provide different grounds for the dissolution of marriage. In India, these theories have been incorporated into various laws applicable among its citizens and have widened the scope and ambit of divorce laws. These laws include the Divorce Act 1869, which is considered as the first legislative attempt to recognize the institution of divorce in India, though it is applicable to Christians only. The marriage and divorce among Hindus is regulated under the provisions of Hindu Marriage Act 1955. For Muslims, it is recognized both under uncodified Shariat laws as well as codified law in the form of Dissolution of Muslim Marriages Act 1939. The Parsi Marriage and Divorce Act 1936 is a law which regulates both marriage and divorce among Parsis in India. The secular law in the form of Special Marriage Act 1954 contains the provisions for divorce based upon these theories of divorce. Now, the theories of divorce. The emergency of Industrial Revolution during 18th century in England and Europe started demanding liberty and equality in all spheres of life. The indissolution nature of institution of marriage no longer remained tenable and it becomes vital to provide people the privilege to dissolve it. However, certain factions still emphasized upon safeguarding it as a social institution. This led to the emergence of fault theory, under which the parties to marriage were provided with certain grounds on which they, under a legally sanctioned environment, were made entitled to seek the decree of divorce, rather terminating it according to their own will. Apart from the fault theory of divorce, other theories came into existence with more and more development in the field of law. A brief discussion of all the theories of divorce can be made as follows. The first theory is fault theory. This theory was first emerged to be known as guilty or offense theory. According to this theory, a spouse can approach the court seeking divorce depending upon the guilt or offense of the other, provided that he or she should be innocent. The offense for which parties seek divorce must be only the matrimonial offense as recognized under law applicable upon them and generally not the criminal offense, however heinous it may be. At first, adultery, desertion and cruelty were recognized under English law as offences for seeking divorce under this theory. Later on, insanity, leprosy, etc. were also added and the theory was renamed as fault theory, since these grounds are more like faults rather than offences on their part. Thus, the theory implicates that if there is any fault on the part of one spouse towards another, then that other party can seek divorce, provided that such fault must be towards that spouse and not to any other person in the society. Since the time of its inception, many grounds have been recognized and included as faults under the theory. A brief study can be made as follows. Number 1. Extramarital sex. When a spouse performs voluntary sexual activity with a person other than his or her marriage partner, then such partner can go for divorce. The ground sometimes is referred with misnomer of adultery, which is not correct. Number 2. Cruelty. The treatment of the spouse with cruelty, whether physical or mental, jeopardizes the foundations of institution of marriage, thus recognized as a ground for divorce. Number 3. Desertion. Staying away from matrimonial bonding for a specified length of time confers the right on innocent party to approach the court for termination the marriage. Number 4. Imprisonment. Confinement in prison for a number of years is another fault which has been recognized under the fault theory of divorce. Number 5. Leprosy. The laws have recognized the disease as a ground of fault theory of divorce if it has become virulent and incurable. Number 6. Venereal disease. Suffering from venereal disease is a communicable form and the fear of infecting the other spouse with a sexually transmitted disease is termed as fault on the part of the spouse. Number 7. Non-consummation or impotency. Some laws consider this ground as a fault for divorce, while others consider it as ground of voidable marriage. If a spouse does not perform sexual intercourse or is unable to perform the same owing to his or her impotency, then this ground can be invoked for grant of divorce. Number 8. Pre-marriage pregnancy. This ground has been recognized as a fault ground of divorce under the Parsi Marriage and Divorce Act 1936, whereas under other laws it has been placed under the grounds of voidable marriages. Bigamy or unnatural offense. The Parsi Marriage and Divorce Act 1936 has recognized this ground as ground of divorce. Bigamy is recognized as ground for declaring the marriage null and void under other laws. The Act has also made available the right to divorce on the basis of unnatural offense to both husband and wife. These grounds have been recognized as faults under the fault theory of divorce on the part of both husband and wife. Either the husband or wife, as the case may be, can approach the court due to any of these faults of their counterpart. The theory and its grounds have been incorporated under different laws applicable among Indians concerning their matter of divorce. The provisions contained under Section 10 of Divorce Act 1869, Sections 31 and 32 of Parsi Marriage and Divorce Act 1936, Section 2 of Dissolution of Muslim Marriage Act 1939, Section 27 of Special Marriage Act 1954 and Section 13 of the Hindu Marriage Act 1955 include these grounds. Except In the case of Dissolution of Muslim Marriages Act 1939, which deals with the right to divorce of Muslim women only, the above-mentioned grounds are available to both husband and wife under all other laws. There are some other grounds mentioned under these laws which are specifically available to the wife, which are: number 1, pre-act bigamy. In the case of a Hindu wife, she can ask for divorce if her husband has committed bigamy before the commencement of Hindu Marriage Act 1955. Number 2, rape, sodomy, bestiality. If the husband is guilty of any of these offences, then it becomes a ground for divorce for wife. Number 3, decree or order of maintenance. A decree or order passed against the husband awarding maintenance in favour of wife becomes a ground of divorce under Section 13, subsection 2, clause 3 of the Hindu Marriage Act 1955. Number 4, forcing into prostitution. Under the Parsi Marriage and Divorce Act 1936, this ground has been recognized as fault ground for which the wife can approach the court for divorce. Number 5, neglect and non-maintenance. If the husband has neglected or failed to provide for maintenance for a period of 2 years of a Muslim wife, she is entitled to divorce under Section 2, subsection 2 of the Dissolution of Muslim Marriage Act 1939. Number 6, other grounds under Muslim law. A Muslim wife can also seek divorce under various grounds such as khula, zihar, laim, etc. The fault theory implies the existence of two things. Firstly, fault of one party for committing any of the specified matrimonial offences, and secondly, innocence of the other party who has been outraged and has no role in commission of such offence. Therefore, it is necessary that relief-seeking party should come before the law with clean hands, which is why it is sometimes also referred to a clean hand theory. There are certain defences available against the theory which are particularly known as matrimonial bars, and these are: number 1, recrimination. It is presumed that the complainant must come before law with clean hands. He or she should not have in any way committed any matrimonial fault in comparison to the fault of his or her spouse. Therefore, a wife cannot claim divorce on the ground of non-consummation of marriage if she has herself deserted the husband. Number 2, accessory. The petitioner must not have been accessory to the fault of the respondent. Number 3, condonation. The petitioner should not have forgiven the fault of the spouse either in implied or express form. Number 4, connivance. Non-opposition to the spouse's marital misconduct, like in the case of adultery, will weaken the case of petitioner. Number 5, collusion. There should not be any hidden agreement between spouses to seek divorce unless it is in consonance with the consent theory of divorce. Number 6, reconciliation. Resumption of marital obligation works as a matrimonial bar at the time of granting of divorce. Number 7, delay. There should not be any unnecessary or improper delay in instituting proceeding for divorce after the finding of fault of the spouse. Second theory is consent theory. According to this theory, when both the spouses decide mutually to put an end to their marriage, they should be permitted to do so. The theory can be very helpful under circumstances where there is no legal ground available to the parties to terminate their marriage, but still they wish to come out of it. In that case, they both can settle their terms for their marriage to get it dissolved. Once they consent to do away with their marriage, it is impractical to compel them to continue with their marriage. Therefore, they should be allowed to resort to a simple way of coming out of the marriage. The way has been laid down by the consent theory of divorce. The theory is based on the notion that the parties should not be compelled to continue their matrimonial bond, as it will be ultimately result into matrimonial delinquencies which will again give rise to grounds for divorce. Therefore, In order to avoid further agony and mental torture, the parties to a marriage should be given an opportunity to mutually dissolve their marriage. If not, then they will certainly resort to ways prescribed under laws and will approach the court, where they will level allegations and counter allegations against each other and try to contest their case for grant of divorce by proving that it is wrongful conduct of other party which has made them to make public their marital issues. So, it is favorable both to the spouses to marriage as well as to the society at large to grant divorce before the matrimonial life is spoiled by the degeneration of one or both of the spouses. On the other hand, it must be kept in mind that while granting divorce on the basis of the consent theory, the court should satisfy itself that the consent of other party is free from coercion, undue influence, etc. If the consent of other party is received out of any malpractice on the part of the petitioner, the court may refuse to grant the divorce. Some jurists have also blamed that the theory is more or less in the form of collusion between the parties to end their marriage, but this is due to misunderstanding between the consent and collusion. Every collusion is no doubt by consent between the parties, but every consent between them does not mean collusion. Sometimes they just simply want to come out of their marriage, and it is not good to keep them bound just because of some legal intricacies. The theory is basically special in its own form, as in this form of divorce, both the parties come forward together to get their marriage dissolved by way of divorce, rather than approaching the court for making allegations on the basis of fault of another. All it requires is the presence of genuine desire to get rid of each other. The theory has been recognized and incorporated under Section 10A of Divorce Act 1869, Section 32B of Parsi Marriage and Divorce Act 1936, Section 28 of Special Marriage Act 1954 and Section 13B of the Hindu Marriage Act 1955. Under Muslim law, the consent theory of divorce finds its place in Khula and Mubarak forms of divorce. Number third theory is breakdown theory. Breakdown of marriages can be defined as a failure of a marriage under which no reasonable probability remains for the spouses to stay together as husband and wife owing to the non-willingness of one or both towards it. The purpose for which the institution of marriage has come into existence will stand shattered if one of the parties is no more willing to continue the marriage. The maladjusted spouse in a marriage will do not good for the society and for the marital couple as well, if he or she is forcefully made to continue with marital bond. For such maladjustment, that party may think to dissolve the marriage, whereas others still wishes him or her to go with it. In such a scenario, the willing party may even try his or her best to make the marriage a success, but all it goes into vain, where the other spouse behaves reluctantly to get the marriage dissolved. There are cases in which spouses live separate from each other for a long period of time, and just because one of the parties wants the marital bond to continue, there is no way out for the other. The restrictions prescribed for grant of divorce under the fault theory in the form of matrimonial faults cause injustice if there is no such fault or offence committed by the respondent, or if such fault is of such a nature that the parties to marriage do not wish to divulge it. It will lead to a situation when nothing amounts to any matrimonial fault, for which the unwilling party can approach the court, but still the marriage is not yet going. Such a situation is called as breakdown of marriage and leads to the emergence of breakdown theory of divorce. The theory has been recognized in several countries of the world. In India, it has been recognized and incorporated under Section 10, subsection 8 of Divorce Act 1869, Section 32A of Parsi Marriage and Divorce Act 1936, Section 27, subsection 2 of Special Marriage Act 1954 and Section 13(1)(a) of the Hindu Marriage Act 1955. These provide that in case whether there a decree of restitution of conjugal rights or decree of judicial separation have been passed and since its passage the spouses have been failed to resume the cohabitation for a specified period of time, which may be 1 or 2 years as mentioned, as the case may be, the marriage is said to be reached the stage of breakdown, thus providing them the ground of divorce. Number 4 theory is will theory. The most discreditable theory of divorce is will theory, where a party can divorce his or her spouse whenever he or she wishes. The peculiar thing about this theory is that under the theory, it is not divorce which is difficult to achieve, but it is the institution of marriage which remains skeptical to the wishes and pleasure of a person who can dissolve it any time. The theory is not recognized under most of the legal jurisdiction of the world. The theory seems to stand equal to the indissoluble theory of marriage for causing injustice to married couples, whereas the former gives arbitrary power to dissolve the marriage without prescribing any reason and brings instability to the institution of marriage. The latter prohibits the parties to go out of the eternal institution of marriage, thus making them to suffer for the remaining part of their lifetime. Number 5 theory is frustration theory. A marriage may sometimes be said frustrated owing to some reasons and needs to be dissolved for the same. There may be circumstances when the other party is not guilty of any matrimonial offense or fault, but there is some activity on his or her part which certainly frustrates the institution of marriage. These circumstances are: number 1, conversion of religion. Apostasy has been recognized as a ground of divorce. Number 2, insanity. Mental disorder or psychopathetic disorder of one spouse when becomes the source of agony for other can be used as a ground of divorce. Number 3, renunciation of world. The basic purpose of marriage is to provide the company and to perform marital obligation with another spouse. If a spouse renounces his or her worldly life and enters into a religious order, it will frustrate this basic purpose of marriage, for which it has also been recognized as a ground of divorce. Number 4, whereabouts not known. When the whereabouts of a spouse are not known for a specified period of time, he or she is declared to be missing from the world and ultimately it becomes the ground of divorce due to the fault on the part of the missing spouse. Number 6 theory is irretrievable breakdown theory. There may not present any ground depending upon which spouses can divorce, but still their marriage needs to be dissolved as it has reached such a position that it has been broken down beyond all attempts of reconciliation. Such a position is termed as irretrievable breakdown of marriage. Though it has not been recognized and incorporated so far under any of the statute, the Supreme Court can exercise its jurisdiction under Article 142 of the Constitution of India 1950 to grant divorce to the parties whose marriage has been broken down irretrievably. The ground has been infused to grant divorce in a catena of judicial pronouncements such as Sandhya Rani versus Kalyanram Narayani, Naveen Kohli versus Neelu Kohli, Jaya Chandra versus Anil Kaur, etc. It is being felt that it should be made a statutory ground of divorce under Indian matrimonial laws. With this, we come to the end of today's topic. Hope you have understood it well. Thank you and stay blessed.